Hi everyone, and welcome to today's webinar, Common Issues in Bankruptcy. My name is Catherine Bowden. I'm in the Community Legal Education team with Margaret here, and I'd like to introduce Paul from the Civil team, who I'm sure you all know very well. Just like to begin today by acknowledging the traditional owners of the land on which we meet and pay our respects to elders past, present and emerging. Now today's webinar, as you all know, is for community legal education purposes only. Okay, we'll run through some housekeeping slides. I'd just like to check that everyone can hear us. So if you can hear me, please just raise your hand. Okay, lovely. Welcome to pop those down. I can see you can hear us. So if you would like any more information on bankruptcy, you're welcome to visit the Information for Community Workers and Carers page on Legal Aid Queensland's website. And technical help is available on 1800 136 402. We've got two handouts for you. One is the PowerPoint slides. Another has some very important contact details which might come in handy, so you're welcome to download those now. I'd like to invite you to submit your questions anytime as we go through the webinar, and then we'll have some space at the end to go through and answer all of those. Okay, now you might notice that we're wearing a couple of daggy jumpers today. So we would just like to support Brisbane Youth Service, who are raising awareness for youth and for homeless people who are young, under 18. Okay, so run a poll. Which area do you work in? Southeast Queensland, Far North Queensland, regional or outside of Queensland? I can see there's a really good mix today actually. We've got a lot of you from outside of Queensland, so Paul will be able to let you know which areas will apply for your area. We've got a lot of people from regional and far north Queensland as well, which is great to see, and a lot from southeast. So I'll close that off and I might share the results just for your own interest. Okay. One more poll. How would you rate your knowledge of bankruptcy? Do you feel like you know a lot about bankruptcy already and you'd like a refresher today? You've got good or limited knowledge, or you don't know much about bankruptcy and that's why you're here to learn today? Again, a pretty good mix. Most of you have limited to good knowledge, so I'm sure Paul will be able to help you out with a lot of things. And again, I'll share those with you for your own interest. Okay, lovely. I'd like to pass over to Paul in Civil Justice Services to run through the presentation today.
Excellent. Thank you, Catherine. So, one of the things I'd say just right at the beginning about all of bankruptcy in general is I'd like to acknowledge the work Financial Rights Legal Centre from New South Wales and the Lismore and District Financial Counselling Service did putting together the bankruptcy toolkit that I'm sure many of you are aware of. It's an excellent resource that if you're not aware of it, please let us know and we can direct you to where that is available for you to use and look at. So that's a really important place to start. The other thing I would say is this, on the whole, this presentation is aimed at those people who have probably a limited to good knowledge of bankruptcy already, following up from a previous, more basic bankruptcy webinar we've done. To those people who already have an excellent knowledge, please feel free to shoot questions through to us, because that's probably the best way of you letting us know the specific issues that you want to get out of this webinar, and we can address them as part of the question and answer process. But without any further ado, let's move to the subjects that we're going to look at today. And basically what I wanted to do today was have a look at the major different types of bankruptcy or debt agreement issues you guys are likely to see, what happens to secured assets, how gambling gets treated, and what sort of consequences can still occur after the bankruptcy has officially ended. And I think that's an important one, because many of our clients think that once they've been discharged from bankruptcy, there's nothing further the trustee can do. And that's obviously not the case, as I know some of you are aware. So, just to remind you, those of you who have not experienced bankruptcy issues before, bankruptcy is one of those things whereby debtors can be initiated either by debtors or creditors, and it's a way for people who cannot meet their debt obligations to get a fresh start or find a way out of the very severe debt problems that they find themselves in. The downside to that for those clients is that they will often lose control of their finances for the period of bankruptcy. Now, many of our consumers in vulnerable circumstances actually don't mind this, because they say things to me like, well, it means none of the debt collectors can call me. They all have to call a trustee. Now, linked to that is the issue around hardship, which many of the financial counsellors listening in already do an excellent job in. But there are some instances where hardship variations don't solve the problem for the unique circumstances of the client. And that's why we end up talking about bankruptcy. All right. The issue I probably want to spend a bit more time on today is debt agreements, because debt agreements are probably, in my view, the most misused of all the potential bankruptcy options, because they're often marketed as debt consolidation, or they're often marketed as alternatives to bankruptcy. Now, the reality of it is that they're set up under Part 9, but the consequences are often very similar to bankruptcy. And in the circumstances our clients find themselves in, they may not be any better option than the existing bankruptcy. And we'll explain that a little bit further as we go on. But the other thing, and I think this is probably the most misunderstood thing by our clients, is if you propose a debt agreement to a creditor or creditors, that's actually an act of bankruptcy and can lead to you being potentially made bankrupt if that debt agreement's not accepted. All right, I'll pass over to Catherine for another poll.
Okay, great. So we'll just launch this one now. We've got a true or false question. Personal insolvency arrangements are made with creditors to make periodic payments or transfer property or money. So take a guess, true or false? We've got pretty mixed answers coming through, or about 50-50 for true, false. I'll let a few more people get their responses in, but it's really looking 50-50 still, Paul.
And that's part of why I thought it was worth us talking about personal insolvency arrangements, because it's probably not something that many community workers ever see. It's probably more bankruptcy and debt agreements that they see out there.
Yeah, all right. Well, let's get the answer. Is it true or is it false, Paul?
Well, let's move to the next slide. So, it's actually true. Now, these are, as I said, I would suspect that not many of you out there would have actually seen one of these agreements, because they're set up under Part 10, similar consequences to bankruptcy, and they are where you can agree to make periodic payments or transfer property or money. And in that context, rather than, I guess, having more restrictions on how you negotiate or how the debt agreement will operate, these are set up with a view in mind of those people who probably have a bit more negotiating power to deal with their debts. And the other issue as to why you wouldn't see them is the controlling trustees that are appointed to personal insolvency arrangements are incredibly expensive. And in the context of our clients who don't have any money to begin with, it's not something they can afford to enter into. But it's just worth being aware that there's that third option out there that you will occasionally see. All right, The key thing I probably get asked most about by most of our clients is what's going to happen to my house, what's going to happen to my secured property. And that can be a house, it can be a car. Occasionally, those people who help clients in WA or Queensland following the mining downturn, that might include a boat or other sort of pleasure watercraft or pleasure craft. That's what they want to know about. And the answer about secured assets, and I'll focus on houses, is the trustee, say on the title of your house, instead of it being Joe Smith owning an interest in the house, it will be Joe Bloggs, the trustee for the bankrupt estate of Joe Smith. And so what happens in that sense is you lose your interest in the house to the trustee while you're bankrupt. That doesn't automatically mean the house will get sold by the secured creditor. The secured creditor still needs an act of default in order to sell the house. But the reality of that is often people who are looking at going bankrupt are often in a financial position whereby they're behind on a lot of debts, and that includes their mortgage. So in that context, what you see is the trust, if the secured creditor acts on the default, the property will still end up being sold. If there is no default to act on, it's the trustee who's going to end up making a decision about whether or not that property should be sold in order to pay towards the debts that the person has gone bankrupt on. Now, and I see a question around tools of trade, which in a way is linked to secured assets, but we'll just raise it. We'll just raise the issue now. In a bankruptcy, you have a threshold value for your tools of trade that you're allowed to keep when you go bankrupt. The last time I checked the threshold for tools of trade, I believe it was $3,700, and that should be assessed on the second-hand value of those tools. So the view of AFSA is that if you have $3,700 worth of tools of trade, that should be enough for you to continue to run your business. That's different to debt agreements, whereby the secured assets are not normally sold. But again, the key issue is whether or not you're in default on that secured asset. And the key bit to highlight there for cars is remember that you have an entitlement to keep a car to the value of $7,800 in equity. So if you have a secured asset, a secured car that's worth $15,000, and you owe $10,000 on that car, can't be taken by the trustee because it doesn't have equity in excess of $7,800. All right, finally, PIAs, and that's the personal insolvency arrangements. Assets don't automatically vest in the trustee. However, the reality of those is that the proposal will often deal with those issues. And like I went through before, you have the ability or a bit more freedom to try and negotiate an appropriate arrangement in that context. All right. The other issue, and I think for me, this is the key difference between bankruptcy and debt agreements, is around ability to work. Bankrupts are disqualified from being a company director. Debtors in a debt agreement are not. The difficulty there for people is it's not necessarily about the company director being an issue. It's for your clients who might be running a small business or might need a license to operate the business they're doing. There are a number of professions where you cannot run a business in that profession while you are bankrupt. And that can be a good reason for those clients, if they can afford it, to go into a debt agreement. Regarding the length of time for bankruptcies and debt agreement, bankruptcy usually lasts 3 years and 1 day. Debt agreements, I've seen anywhere between 3 and 5 years. If I see a debt agreement that's going longer than 5 years, I have big concerns over that, because the reality is having somebody meet a fortnightly payment for more than 5 years in a row is asking a bit much of our clients who are in difficulty. The other issue around this, and I know a number of you are aware of this, there is a bill currently before the Federal Parliament as the Bankruptcy Amendment Enterprise Incentives Bill of 2017. And one of the things it looks at is the possibility of reducing the length of a bankruptcy from the 3 years to discharge you after just 1 year. That hasn't yet passed Parliament when I checked yesterday. It's still before the Senate. My understanding is the committee that looked at that bill reported on the 12th of March and was overall supportive of it. But until that gets passed, we're still in a position where the bankruptcy lasts for 3 years. If that bill does get passed, my understanding of the transitional arrangements of the legislation would mean that existing bankruptcies would also be subject to a 1 year period before it can be discharged rather than the current 3 years. However, until we get that legislation passed by both houses of the Federal Parliament, the existing law we're still going with is that bankruptcies are 3 years and 1 day until the discharge happens. All right, the other thing worth knowing is around income. There's no income taken out from debt agreements. However, you must meet the fortnightly payments. Bankruptcy, there's income thresholds which vary depending on the amount of dependents that you have as to whether or not you need to make an income contribution. The reality is most of the clients I see don't meet the income threshold and so don't make income contributions on bankruptcy. But it's always important to check how that works. The issue I have around debt agreements is you have often people who are on a pension, they might be receiving Centrelink, they might be on a DSP. And in that context, I question whether a debt agreement where somebody's agreed to make this continual payments for a 3 year period can actually achieve that when, let's be honest, their Centrelink income or their pension isn't going to increase in any way, substantial way. But expenses such as electricity, food, water, telephone, other basic necessities are usually going to increase quite substantially over that 3 to 5 year period, which makes it very difficult for people to successfully complete a debt agreement when they're on a fixed income. My answer would probably be different if they're going back to work and are aware of a substantial income that they're going to earn. But where they're on a fixed income already, my experience is they don't successfully complete the debt agreement and end up going bankrupt anyway, whether it be a year or 2 years down the track. And given people often want to be out the other side of these issues, those sort of circumstances where you go a debt agreement, it fails, and bankruptcy will often cause our clients some distress. And this slide just goes into what I was talking about in a bit more detail. And we've highlighted the fact that the payments are often unaffordable and the issue of the fixed income. And we've highlighted the idea that clients' circumstances are likely to change and that their expenses are likely to rise during that period. The other thing, and I touched on this briefly before, is that clients, and sadly I think it's a majority of clients I see with these issues, liken a debt agreement to a debt consolidation loan. And a debt consolidation loan, and I'm sure you guys understand this already, it's where you consolidate all of your loans into a credit product. It's not a situation where you enter a debt agreement, even despite the advertising which we will see out there that suggests you can easily consolidate your loan in this way. The consequence, as I said, is that most of these people will end up in bankruptcy.
Okay, another poll. So I'll just launch this one now. All right, you've got, I guess, 3 answers to choose from. A debt agreement may not be the best option for your client if their income is low enough that they would not have to pay income contributions in bankruptcy. They are not a company director and do not want to be one, or both answers are correct. So we've got some pretty mixed responses coming in here. And we'll just give you a few extra minutes on this one. When a debt agreement may not be the best option for your client. Okay, looks like the majority of answers are in. I'll share those with you now. And Paul?
And the answer is actually both, in the sense that if you've got a low income, debt agreement is not going to help you because we think it's unaffordable. But it's also an issue of, if you don't want to be a company director, then that's about one of the few good reasons to go into a debt agreement. But I understand why people would have just answered low income, because my experience of the type of clients I see at Legal Aid is that I might have encountered 2, maybe 3 clients in the 10 years I've been working who've been concerned about the company director issue. But it's important to still be aware of it because it's something that you will occasionally see. So I think we've covered that slide already. But I put the detail in there for you to take away as part of the slides. It sets up a nice statement there of 4 points as to when a debt agreement may not be in your client's best interests. Now, this is the other one, particularly with the funding financial counsellors have got to deal with gambling issues, that I suspect presents a fair bit. And that's where a client has incurred some of the debts they want to go bankrupt on because of a gambling addiction. Now, I'll say right up front, my view about this issue is what people are suffering from in this space is an illness. It's an addiction like any other. But we need to be aware of this section 271, which does say if within that 2 years before you present the bankruptcy petition, you've lost any of, or you've created any of that debt by reason of gambling or speculation that was rash and hazardous, being gambling or speculation not connected with a trade or business, and you go bankrupt, there is a risk that AFSA could criminally charge you, and potentially you could be subject to a term of imprisonment of up to 1 year. Now, the Inspector General does have a practice note, and I've given you the link in the slides to that practice note. And for me, the nub of that practice note is they're not intending, as a general rule, to go after people who are the victim of an addiction. However, the reality of the section is such that I'm always very wary of people wanting to go bankrupt when they've incurred some of the debt due to gambling. And so in that context, I'm always very clear with clients to spell out that this section exists and that there is a risk that if they go bankrupt on debts incurred by gambling, that AFSA could take a good look at it. And AFSA, for the benefit of our newcomers, is the Australian Financial Security Authority, who are the regulator who oversees this area, and that includes the bankruptcies and debt agreements and the administrators who look after debt agreements. So if there's specific questions about the gambling, I think it's important personally that all clients are aware of this section so that they're making a decision about whether to go bankrupt based on all of the information and the potential or risks that go with going bankrupt on something related to gambling. If there's any specific questions about gambling, please shoot them through, because this is a topic that I know does cause community workers some grief. All right. The other section I wanted to have a bit of a look at was what happens after you've been discharged from bankruptcy. And when we say discharge, that can either occur when the bankruptcy ends, and that's usually we're talking about 3 years and 1 day, or in some rare circumstances, a bankruptcy can be annulled, where the debt's paid off or the debt was never actually there. Now, my experience of annulments for our clients is they're almost never successful. And the reason seeking to annul a bankruptcy is almost never successful is that when you're annulled, you've got to pay the costs of the annulment application, and you've also got to pay the trustees' costs that they've incurred as part of the bankruptcy. And the reality for our clients is affording to pay all of those costs in addition to paying off their debts is not a realistic option. So that most of what we're talking about occurs when the bankruptcy, through a discharge of the bankruptcy. The only exception to that around annulments is if somebody gets an inheritance usually. And my experience of that is that's very rare. I have actually had a couple of circumstances where somebody's been able to pay up the debt, but they haven't been able to afford to pay up the trustees' fees, and so haven't been able to annul the bankruptcy. Also be aware that the trustee does have the power, say if the bankrupt leaves the country, or if they do not cooperate with the trustee, to make an application to extend the bankruptcy. Or similarly, if super contributions are made to defeat creditors, they have the option of extending the bankruptcy again, as set out in the slides. The issue around property is another one, and this has come up a bit, at least in Queensland, around properties in mining towns where the property value dropped quite substantially a few years ago. And my understanding is it's also a problem, particularly in Western Australia, following the mining downturn. Often what happens in this story is the trustee will decide not to sell the property during the period of the bankruptcy, because to sell it would not realise any equity and would in fact realise a loss. However, their power to sell the property or deal with the property does not end when the bankruptcy is discharged. And as I've set out in that section 129AA3, it sets out this idea that they've got up to 6 years for the property to be reinvested from when the bankrupt is actually discharged. And that's one of the things, at least in my experience, a lot of clients haven't dealt with or haven't understood, that there are lingering effects to a bankruptcy that we all should be aware of. And we should all remind clients that just because they've been discharged doesn't mean their responsibilities to talk with their trustee and for property to be dealt with have ended. There's also worth saying that there's a number of debts that don't end when a bankruptcy is discharged because you couldn't prove them in the bankruptcy. And I've set out a number of them there. Child support being a clear one. A debt incurred by fraud is another. Some debts, such as toll debts or court fines that arise out of, well, toll roads is a big one in Queensland at the moment. And I know it's a big issue in New South Wales and Victoria as well. And some student help debts are another one. But the third dot point on that slide is one that I think is a really big issue. And that is often you'll see people going bankrupt because they've been involved in a car accident and they're being chased for the damage they've caused to the car because they haven't been able to afford comprehensive insurance. So be aware that if the client's going to go bankrupt, it's important to quantify what that loss is. Because if it's not, there's an argument that the debt can still be chased following the bankruptcy. And if somebody's in that scenario, they really should get legal advice about it and about what their responsibilities are. The other thing I'd say, although it's not bankruptcy related, that's important to be aware of in that car accident space, is it's important to remember that the General Insurance Code of Practice actually has a hardship section in section 8, whereby they're required to look at a person's financial circumstances if they raise the issue that they're not in a position or won't ever be in a position to be able to pay a debt that they've incurred following a car accident. All right, I'm not going to go, I don't think, into the annulment process in any great depth, apart from to say, as I said earlier, that I almost never see an annulment being successful because our clients can't afford it. If you've got any questions about that process, please shoot them through to us and I can reply to you after the webinar. All right, we've got to the end of the slideshow, which means Q&A.
Yes. Okay, so we actually had quite a few of you asking some questions to Paul before the webinar started. So I might just let Margaret read the first one out now.
So Paul, if an individual applies for personal bankruptcy and they've got a mortgage on their home and it's in both names, will that impose a risk on the wife and or the home they live in?
Yeah, and it's a really good question because I think it's a question that comes up quite a lot. And the answer is when somebody goes bankrupt, the trustee then goes on the title of the property in their place. So it will appear as the owners of the property are the person's wife and the trustee in bankruptcy. And what usually happens in that case is if the trustee decides to sell that interest in the property, they will usually but don't have to, ask the wife whether they want to purchase the bankrupt's interest in the property. But if their wife is unable, they will often sell that half interest or that however big the interest is in the property in the normal way you'd sell a house. So the risk, particularly to the wife in that scenario, is you might end up with the wife continuing to own the property and somebody she's never met owning the other half interest. And that's a really big risk.
Okay, Paul, I've got another question that's just come through now. What happens with tax returns and if a client is affected with bankruptcy? Do they have any extra entitlements around tax returns?
Okay, so I guess the starting point is around tax debts. Tax debts are provable up to the date of bankruptcy, unless the tax office has issued a garnishee notice. And then if they've issued a garnishee notice, they can continue to recover. My experience is around tax returns, if there's a tax debt, the tax return tends to be the ATOs. Because my experience is they tend to have first call because they become a secured creditor. Tax returns otherwise will be treated, my understanding, as income as part of the bankruptcy. And the trustee makes the call as to how that's dealt with if we're above the income threshold.
Okay, that makes a bit more sense, Paul. Might hand back to Margaret. You might like to read another couple out.
So what's the responsibility of the intended bankrupt to notify anyone that they hold joint property with?
Okay, so the responsibility around going bankrupt is it's the creditors that need to know, not the person holding joint property. And my experience of what happens in that scenario is if somebody owns joint property, the trustee is usually very good at letting people know that they now have the interest in the property and the bankrupt doesn't.
Now, are there any major changes that have come through since the 1st of July?
Yeah, and I briefly mentioned this earlier. There is a bill before Parliament that's looking at making some very good changes in our view, or in my view, around reducing the length of bankruptcies and other changes linked to that. The reason behind that is it's less punitive to people, the proposed changes, and might allow I guess, small business people who might have been down on their luck a better opportunity to get back on track earlier. Not past Parliament yet, though. It's a watch this space to when that legislation will commence.
Thanks, Paul. When it comes to a discharged bankrupt, how long does a person have to wait to get a home loan?
Okay. Financial providers and their credit criteria, I think, is probably a source of mystery to all of us as to what they're looking for when it comes to those sort of things. The reality of a bankrupt, though, is when you go bankrupt, there's an entry made on your credit report, which will stay there for 5 years from when you've gone bankrupt as a general rule. And while that listing's on your credit report, you're not going to get a loan.
Right. Okay. I'll run through a couple more questions that have just come through now. What do sole traders need to know about entering into bankruptcy?
That's going to depend. And I think that's going to depend a lot on how they've structured their business. That's going to depend on whether they've given any personal guarantees for any of their business debts. It's probably going to depend on what, if any, property or assets they have in their own name. And so, although it probably sounds like I'm avoiding the question a little bit, it's very much an individual circumstances question there that's going to dictate what's going to be important.
Okay, thanks, Paul. So if you need any more specific information there, you're welcome to email webinars at legalaid.qld.gov.au, and Paul can take a look at that for you then.
Absolutely.
Okay. Someone's got a client that is bankrupt and they've still got credit during this time. Does that happen from time to time, Paul?
Look, the reality is there's no prohibition on somebody getting credit while they go bankrupt or while they're bankrupt. There's an obligation if you're seeking credit above a particular threshold. The exact amount of that threshold at the moment escapes me, I'm sorry, that you have to disclose that you're bankrupt in your application for that credit. Without knowing the particular circumstances of that case, I suspect that was probably for a smaller amount of credit, whereby the lenders made a decision that they believe the person has the financial capability to pay it back without substantial financial hardship. If I'm a creditor and I see a person doesn't have much money and that they're bankrupt, I'm questioning whether that's a particularly sound decision to lend somebody in that position money when their experience would suggest that they're in circumstances where they're going to find it hard to pay back. And any credit in that scenario is going to have to be lent, still meeting the responsible lending obligations under the national credit law. And you'd want to have a very good justification, I think, of those responsible lending criteria being met in circumstances where somebody is bankrupt.
Yeah, absolutely. And Paul, just going back to the 5-year record of bankruptcy, does the credit report then clear after that 5 years?
The credit report then clears, but at the moment, the National Personal Insolvency Index, once you're a bankrupt, you remain on that for, somebody described it to me the other day as you remain on it for perpetuity, even after you're dead. I've never actually looked at the beginning of that index, but as I understand it, there's everybody that's been bankrupt since the Commonwealth of Australia started on this legislation. People tend to, but the reality is creditors tend to check the credit report. They don't always check the National Personal Insolvency Index.
Oh, okay. Interesting. Margaret, have you got another question there from one of the attendees when they registered?
Just in relation to self-managed super funds and trusts, are they protected or are they deemed as income?
Okay, so starting point around super is funds in a superannuation fund are protected in bankruptcy and are not available unless they're withdrawn prior to the bankruptcy. However, the exceptions to that are, so you can't, for example, be wanting to go bankrupt and then put a whole heap of your money into your superannuation fund and think that the trustee can't get it, because that's something that's designed to defeat your creditors getting the money. And so that's not okay. And it's similar rules that apply to self-managed super funds, assuming they meet the criteria of a regulated super fund under the superannuation legislation. Money that's withdrawn after is usually okay, depending on how the superannuation fund is structured.
Okay, thanks, Paul. Just got another question about Centrelink here. Just give me a second to read this one. Centrelink income is protected in bankruptcy, but will this income be garnished to pay debts not extinguished by bankruptcy?
Yeah, so the reality of it is the debts will be still payable once the bankruptcy ends.
Okay.
And so in that sense, you're quite right in your conclusion that eventually the Centrelink income will be used to pay debts which are not provable in bankruptcy. And it's really important to remember that, because the Centrelink income will be protected for the period of bankruptcy. But once the bankruptcy ends, as our attendees identified, then it potentially could be used.
Okay, thank you, Paul. We've had actually quite a few questions come up about company directors. So I might run through a couple of these. The first one is, does that mean that once the client is out of bankruptcy, they can then become a company director?
Look, there's probably a legal answer to that, and there's probably a practical answer to that. In the sense of, while you're a bankrupt, you can't be one. Once you're discharged, in theory, that prohibition is lifted. The practical reality is if I'm appointing a company director and somebody's been bankrupt, I'm probably thinking fairly seriously about whether I want to appoint them as company director.
Yeah.
So while that's not a legal answer, I think the practicality is, once you have been bankrupt, you might find it very hard, unless you're the one creating the company, to get yourself appointed as a company director.
And Paul, the other question was, are there restrictions around becoming a company director while you're in bankruptcy? And would that last the full 5 years?
So while you're bankrupt, you can't be one, is the short answer.
And that would be that 5-year period. Yeah.
Well, sorry, for the period of bankruptcy, however long that lasts.
Okay.
If someone is assisting a client in completing forms and explaining terms and whatever, should they be doing that due to any legal ramifications? Okay,
so what I understand we're talking about here is there's a section on the bankruptcy forms about where a person who's helped somebody fill out the forms will often sign. Now, my understanding is, and this is probably a very, very much a service by service response, is that by signing that document, you're arguably, in a sense, saying that you've looked over the documents and you're almost agreeing to what the client has put in there, or saying you've helped, they've explained it, and you understand what's happening. Now, some services may view that as a risk to what they're doing, because it might be viewed as going beyond the scope of what they do. The reality of what all of us do is, either through advice or helping with forms, we do help people with bankruptcy. It's probably a procedural question for your own services as to what your service is happy doing. And I suspect a lot of those services have sought independent legal advice about what their own appropriate independent responses should be when it comes to whether they fill that part of the form out or
I've got one other question, and this is a question that from myself,
Yep.
Particularly in relation to company directors, but also where does the responsibility lie for people coming onto boards, and they may not be under ASIC, they may be other forms of incorporation.
Yep.
Whose responsibility is it for the declaration, of people's financial circumstances if they've been bankrupt or they're currently bankrupt? Because often it's left to the individual to make that declaration.
Look, I would have to double check the corporations law to answer that question. Top of my head, don't know. It's a really good question though. Obviously, there's responsibilities around answering questions honestly regarding any sort of application or any sort of information you give people. But beyond that, I'm sure it's dealt with specifically in the company law. I just don't know what the answer is.
Okay.
We've got a few people who are wanting a little bit more clarification around tax.
Yep.
So one of the questions is what tax debts can't be claimed in bankruptcy?
What tax debts can't be claimed?
Can't be claimed.
Okay. Look, penalties imposed by the tax office are provable. But if you're at the point where the tax debt's seen you get court-imposed penalties or fines, then my understanding, in the same way any other court fine isn't provable in bankruptcy, the same thing would apply there.
Okay, thanks, Paul. And I know we might have run over this, but it will be a good refresher. What happens with personal tax debt in bankruptcy, not GST, but personal income tax debt on an integrated tax account?
I think that's going to require some more information about the individual circumstances, because that sounds like a very specific client-related question to me, and I'm happy to go into that further with somebody offline.
Okay, so just a reminder, if you've got specific client questions, the email address is webinars@legalaid.qld.gov.au, and you've also got some contact details in the handout there as well. All right, back to company directors again, Paul. We've got a couple of questions around company directors and employment, so maybe we should spend a little bit more time on this. Does the ban on being a company director apply to being an office holder of an incorporated association?
I'm going to need to look that up.
Okay,
Don't know.
If you'd like to email us that question, then Paul can look that up for you. And Paul, are there any other restrictions on employment? For example, if someone would like to work in a bank after they've been discharged?
Look, the restrictions on employment are very much profession related and very much dependent on what profession we're talking about. I don't know what specific requirements maybe individual banks have around employment for those things. I do know, for example, that there are restrictions around certain types of builders licenses that you can't hold while you're a bankrupt. And so it's always a case for me, my advice usually in that scenario to people asking those questions is you need to go and ask your professional organisation what their requirements are. Yeah.
That makes a lot of sense. Just a reminder, everyone, that we've still got 10 minutes left. So thanks for sticking around for the Q&A. If you've got a burning question, now's a great time to get it out there. Otherwise, we might keep running through some of these that have been asked online. Have we covered everything, Margaret?
I think we have. I think some of it, well, quite a lot of it, Paul has already covered in his presentation. So
okay, lovely. Then we'll stick to these that are coming through now. So what happens to rates, water and sewerage, body corporate expenses and the likes that are linked to reduced value properties?
The obligation is still there to pay it, unfortunately, in the sense that the property can be gone after by councils or the body corporate. The practical reality is...
what do people normally do in that situation? If they're bankrupt, they don't have the money to pay it. Do they then start accruing debts?
Look, not a question I've had come up.
Okay.
And I'm not really sure why, because it is something I would expect that would come up quite often.
Yeah.
So I think that's probably another one I have to go away.
Yeah. Okay. So again, please email the webinars inbox. Because,
really good question.
Yeah, and we can, if anyone does email us with their questions, we can send it back to you individually, or if you don't mind, we can send it out more broadly so that everyone who's listening.
What I would say about rates and water and sewerage is that the response of council is very mixed, and it's very dependent on individual councils as to whether they're willing to give longer term sort of hardship arrangements to pay that sort of stuff back. My experience with body corporates is very different. They are generally more willing to see people go after property even while people are in very difficult circumstances.
Okay, thanks, Paul. Someone's asking here, if you earn over the threshold and pay some money towards your debts while you are bankrupt, do you make higher repayments after the bankrupt period then ends?
I'm not 100% sure what we're driving at with that question, in the sense that once you earn over the income threshold, the trustee will take a percentage of that income and pay towards the debt. But if it's a debt that's in the bankruptcy, what happens on discharge of the bankruptcy is that provable debt isn't there anymore, and you have no obligation to pay it any longer. So if person sending through that question would clarify exactly what you mean by higher repayments after the bankruptcy ending, that would be great, because if the debt's included in the bankruptcy and is provable, once the bankruptcy ends, there's no further obligation to pay it.
Okay. All right. Yep. So you're welcome to submit some more information or email us to that one. That'd be lovely. Oh, okay. So so if you've got a couple and one partner is bankrupt, which is only in their name, what happens if there was a prenup in the relationship and both parties then are responsible for the bankruptcy?
I'm quite happy to acknowledge that my knowledge of family law is next to zero. I would recommend you referring that person either to a private family lawyer or the relevant legal aid commission for advice around family law in that space, because I don't think I've ever seen a prenup in a legal context, because I've never done family.
Yeah, that's right. So Paul is a civil lawyer, but yes, you're very welcome to call the 1300 line to speak to our family lawyers or take Paul's suggestions for referrals there.
Cool.
Okay, lovely. So it looks like that might be all the questions we have today. Paul, have you got any top tips that you can leave the audience with? I know we've had a lot of really valuable questions come through, but if you could just leave everyone with one or two tips, what would they be?
Look, the couple of tips I'd say is in the space collectively that we're all in, I very rarely see clients in circumstances where debt agreements are a good idea, usually because they're unable to complete the debt agreement, and that has consequences down the track. And the second issue is around this company director issue. And we got a whole heap of questions around that, to be honest, I wasn't expecting, because it's not something I see very often. But my rule of thumb there is, if you're wanting to be a company director, bankruptcy rules you out of it. If there's other specific issues around that, the people should get specific legal advice about what it is they're wanting to do, so that they're clear what their options are before they make a final decision. Yeah.
They're great tips, Paul. Legal Aid Queensland is always here to help, so you're welcome to give us a call at any time. You're welcome to email the webinars inbox if you've got questions, and for those of you who have downloaded the handout, you'll see some really valuable contact information on those, so if you haven't done that yet, I'd recommend doing
we
it now.
We welcome those inquiries to our email or phone number, so long as you don't give those contact details directly to clients.
That's right. So it's for your eyes only, please. All right. Thank you, everyone, and big thank you to Paul for such a great presentation. And we had half an hour of questions today, so it was obviously a very valuable topic to our audience, and we really appreciate presenting Paul and everyone joining in with their questions today. Thank you.
Thank you,
Margaret.